Good morning, everybody. Chief Justice, Presidents, colleagues and honoured guests, including the Minister for Justice. As a member of the Supreme Court and the Chair of the Court Service Board, it's my pleasure to welcome you all to the Four Courts this morning to join us in formally opening the new legal year. This is our third such ceremony, hosted in partnership by the Judiciary and the Court Service to mark the occasion that is the first day of the new Michaelmas term, the first day of the new legal year. Formally acknowledging the beginning of a new legal year gives us the opportunity at the start of this year to gather together in a way which is not always possible when a term is in full swing. It's an opportunity for colleagues, old and new, to meet, and it also encourages us as members of the legal community to reset, to reflect on the past year's achievements and challenges, and perhaps most importantly, to set out our intentions for the months ahead, paving the way for a renewed collective commitment to the fair and efficient administration of justice and the rule of law. Last year, we celebrated the centenary of our court system, which gave us an opportunity to reflect on the achievements of our system thus far, but also to commit ourselves to continue to ensure that our courts continue to evolve to meet the needs of a modern Ireland. A further notable event this year was the presentation of the 25th annual report of the Court Service to the Minister, marking a milestone in the history of the Court Service and setting out the significant progress which has been made in line with the Court Service strategic objectives in our long-term strategic vision via our modernisation programme over the last year. As you can imagine, the achievements of the Court Service would not be possible without the input of the wider legal community, and so I would like to thank members of the legal professions, An Garda Síochána, the Irish Prison Service, the Probation Service, government and non-government agencies and civic society groups across the sector for their ongoing assistance, cooperation and support in the pursuit of these goals. You'll all be aware that in line with the recommendations made in the 2023 report of the Judicial Planning Working Group, that we have seen an expansion of the judiciary and anticipate further expansion when the second tranche of judges recommended by the JPWG are appointed next year. There have been 24 additional judges appointed to the District, Circuit, High and Appeal Court since 2023, bringing the total number of Irish judges to 202. The increase in judges has been reflected in the data. The backlog in criminal summonses awaiting scheduling in the District Court decreased from over 61,000 cases at the beginning of 2023 to just 7,300 by mid-24. A 17% increase in circuit court sittings nationwide between 2023 and 2024, the reduction in High Court judicial review wait times from 13 weeks to just 3 weeks, and since 2024, the capacity to hold up to 12 Central Criminal Court jury trials concurrently, which has also reduced the wait times for the trial of serious criminal offences. This is just one way in which we've seen the positive impact of the additional judges in reducing court wait times and backlogs in pursuit of the goal of timely access to justice. Of course, we cannot strive for a more efficient and effective justice system without facing challenges, of which there are many. The increase in judicial appointments has put additional pressure on accommodating judges and court staff, in particular in the Four Courts complex, which was already a building designed for the legal system of a very different era. This will be brought into even greater focus with the appointment of the additional judges. It is clear that the Court Service is not adequately resourced to support an expanding judiciary. While there has been a 5% increase in judges between 2022 and 2024 and a 27% increase in sittings, the human resources of the Court Service has increased by only 2%. There's a big mismatch. The Minister will no doubt refer to the Family Courts Act 2024, which is centred on important principles such as prioritising the best interests of children affected by family law proceedings, ensuring that proceedings are both user-friendly and expeditious, and encouraging alternative dispute resolution where appropriate. The objectives of the legislation in making family law proceedings accessible, expeditious and cost-effective for all parties are, of course, important and welcome, as is the much-needed family law court complex at Hammond Lane. However, it should be borne in mind that this legislation will impact significantly on the work of the judiciary and court service. It will be important to ensure, yet again, that we have the necessary resources and facilities to give life to the objectives underlying this important new legislation. As such, the adequate resourcing of the judiciary and the courts and the continued hard work and collaboration of all members of the justice sector, including those within the courtroom and beyond, is key to solving and resolving the many challenges facing us now in the years ahead. I would now like to invite somebody who is far from being a stranger to these premises and who has graced this part of the building and other courtrooms around the complex for many years as a barrister and senior counsel. But I now would like to welcome him in his guise and capacity as the Minister for Justice to deliver the first keynote address this morning. Thank you very much.
Príomh Brethbh Brethúna daoine uaisle agus a cairde go léir dús bar bhuaithlim buíochas a gháil leis an príomh Brethbh as cura a thuirt sé dom a bheithin seo chuig an ócáid tábhachtach seo maidin. Caithfidh mé rá is mór an ónar dom a bheith in ann labhairt libh ag ócáid oscailt tús na bliana de le thuaille. Tugann an ócáid tábhachtach seo deis dom buíochas a gháil leis na Brethúna agus le fuireann na Coirteanna as a gcuid oibre I rith na bliana sna Coirteanna. Chief Justice, members of the judiciary, distinguished guests, it's a great honour for me to be able to address you on the occasion of the opening of the new legal year. The administration of justice in Ireland has had a long and somewhat complicated history. The imposition and effect of colonial rule in Ireland was very much apparent in our justice system. That is why the justice system that operated before independence was never truly accepted or recognised as being a justice system that belonged to or served the Irish people. Instead, justice was administered in courts that served a system of governance that was not accepted by the majority of Ireland's population. That system of government was repeatedly challenged by those who sought self-governance for Ireland, none more so than Charles Stuart Parnell, whose anniversary we also commemorate today on this Ivy Day. Notwithstanding that system of imposed governance, there was in place in Ireland in the 19th century a justice system that sought to, and in many respects did, administer justice, but within restricted political parameters. It was not a system that we would countenance today, but it was a system of its time which established the foundations for much of the common law that remains in our system. In 1796, as you'll see from the plaque above me, this building became the central location for that justice system and was designated as the location where serious civil justice claims in Ireland were to be administered. Prior to its construction, justice was administered not far from here in 4 courts of Chancery, King's Bench, Exchequer and Common Pleas. When they left their location around Christchurch and came down to this location on the river, those 4 courts established a permanent presence here for the administration of justice. This building is part of the legacy we inherited from that former justice system. Although this building was badly damaged during the Irish Revolutionary period, that period moulded the justice system we have today. When the 4 courts was rebuilt, so too was a justice system that served the needs of the people of an independent Ireland. We established courts and a justice system that had the support of the Irish people. We placed at the centre of that justice system the interests of citizens, not subjects, litigants, not lawyers. Although we see gathered in this hall many judges and lawyers, I know I do not need to remind anyone here that the administration of justice is not about judges and lawyers. The administration of justice is concerned exclusively with serving the interests of those who seek justice in Ireland. Our courts administer that system of justice, and this round hall is the headquarters of that justice system. Article 34 of our Constitution is very clear. It says that justice shall be administered in courts established by law by judges appointed under the Constitution. It is important that this constitutional provision is emphasised and not departed from. Justice is a much referenced word and pursuit. In Ireland, justice is not delivered by politicians or Oireachtas committees or tribunals or inquiries or indeed ministers for justice. It is administered and delivered by courts established or permitted under the Constitution. Where the Oireachtas has established quasi-judicial bodies under Article 37, they too can administer justice in a limited way, provided they exercise those powers in a judicial manner. Even though the Oireachtas has created many Article 37 bodies, the preeminence of the courts as the location for the administration of justice must always be asserted and protected. Our Constitution guides the pursuit of justice. It is a living document that has given expression to fundamental personal rights. It is also a document that establishes the architecture of the Irish state and requires the Oireachtas and government to promote the common good. I know the common good is a concept that can be nebulous, but it does reflect the desire of all arms of government to facilitate the state in enhancing the lives of Irish citizens. In justice, it means that the scales of justice is no longer simply a balancing act between the rights of the individual and an oppressive or interfering state. In many instances, the rights of an individual must now frequently be balanced against the common good. As Minister for Justice, I have no role in administering justice. I am, however, required to ensure that the judicial arm of government has the resources and supports required to fulfil its constitutional obligation. I am also required to ensure that the independence of the judiciary is protected and not compromised. The independence of the Irish judiciary serves a very real purpose beyond protecting judges. Its purpose is to ensure impartiality. This is very necessary in a judicial system that frequently sees the state as a party to or affected by proceedings. I'm the first Minister for Justice to have presided over the nomination of new judges who were recommended for appointment by the Judicial Appointments Commission, the new statutory body that advises government on judicial appointments. This new commission and its very intensive method of seeking, interviewing and selecting new judges is a very strong addition to ensuring the independence of the Irish judiciary. This has been a positive development, not for the Irish judiciary or indeed for the government, but for the Irish public, who can now see a very transparent process for the appointment of judges. The Judicial Appointments Commission Act provided for the largest reform in the way judges are chosen for appointment and includes a requirement that all candidates will be required to show they have undertaken judicial training or continuous professional development. This development will ensure that the Irish judiciary continue to be highly regarded with an internationally recognised record of integrity, fairness, impartiality and commercial awareness. Judicial resourcing is, of course, essential in ensuring that the courts can administer justice efficiently and effectively for all our citizens. Last month, I received government approval to amend the legislation to increase the number of judges in Ireland by 21. This is the second tranche of additional judges, as recommended by the Judicial Planning Working Group. As Minister responsible for access to justice, I am committed to ensuring a modern and efficient court system that continues to meet the challenges and needs of those who engage with it. The Court Service is progressing an ambitious 10-year modernisation programme to deliver digitally enabled services designed around the user. The Court Service also has many projects underway that will improve efficiencies in our courts, to enable greater and more efficient access to justice. These include the rollout of video link and technologically enabled courtrooms and the introduction of a unified case management system, which will enable digital end-to-end journeys supporting court users. The Court Service has launched a new online portal as part of its unified case management system supporting digital applications, responses, case tracking and order collection for circuit family cases in Dublin. This is now in operation for a pilot period, after which circuit family cases across the country will be supported through the portal. Over time, the portal will be expanded incrementally to support other matters, such as the launch of probate via the portal in the coming months. The Court Service has also continued the expansion of technologically enabled courtrooms, providing remote courts and digital evidence display functioning. Video technology is now available in 175 courtrooms, increased from 46 at the start of 2020. The Family Courts Act 2024 is a key component of the government's family justice strategy and contains provisions designed to make the family court process more user-friendly and less costly. It will ensure that family courts will have assigned to them on a full-time basis judges with appropriate specialist knowledge. The Act also contains a set of guiding principles for the family court system to make the best interests of the child a primary consideration in the conduct of all family law proceedings, to operate in an efficient and user-friendly manner which is likely to minimise the cost of the proceedings and to encourage active case management by the courts. Commencing the Family Courts Act 2024 is one of my priorities, and an implementation team has been established within my department. As committed to in the programme for government, I intend to publish an implementation plan for a new family court system by the first quarter next year. Although government has no role in administering justice, it can and should seek to make our system of justice more efficient. Recently, I obtained government approval to prepare a general scheme of the Civil Reform Bill, and drafting of the bill is currently progressing as a priority measure. The Civil Reform Bill is a key implementation measure of the report of the Review of the Administration of Civil Justice conducted by former President of the High Court, Mr. Justice Peter Kelly. Amongst a range of improvements to civil law procedures, the bill will codify the existing law on judicial review, placing it on a statutory basis. As Minister, I recognise that citizens have the right to challenge what they perceive as unlawful decisions of public bodies as a fundamental part of the checks and balances of a liberal democracy. This right must and will be protected. I must also recognise, however, that justice is not a game, the rules of which provide that the winner is the person who catches out a decision-maker who failed to comply with a statutory or procedural step. The common good, as I said earlier, must also be weighed up on the scales of justice. The agendas of litigation enthusiasts who seek to stop important infrastructural developments must be balanced against the interests of the broader community and the common good. I am confident that the Civil Reform Bill will remove weaknesses in the current judicial review regime, eliminate impediments to progress, and deliver reform for the public benefit. I am also confident that the measures in the bill will preserve the right of the citizen to ensure that public bodies act lawfully and are accountable for their decisions. Another major area of reform in the bill is in relation to discovery, which will be replaced with a system of production of documents focused on those documents which parties intend to or reasonably likely to rely on at trial. We cannot stand by whilst discovery makes access to the courts the preserve only of well-resourced or institutional litigants. These changes should result in significant impacts around costs and delays, and they will improve access to justice. The scheme will also provide for case conduct principles which parties to proceedings will be expected to adhere to. I would like to thank the judiciary for its commitment to administering justice. The administration of justice is not about judges, but it cannot be achieved without the tireless commitment of judges. Our justice system is also greatly helped by the diligence and professionalism of practitioners who work to facilitate those who need access to justice. The traditional commencement of the legal year in October in many respects, ignores the fact that the work of judges and legal practitioners in Ireland continues virtually all year round. As Minister for Justice, Home Affairs and Migration, I look forward to the new legal year, embracing the challenges that lie ahead and working towards further progress. In conclusion, I would like you to note that during the Tudor campaign in Ireland, during the reign of Henry VIII, when justice was purportedly administered from Dublin Castle, a recommendation was made in the year 1538 that a new building should be constructed in Dublin to replace the Castle Hall where the law is kept. For if the same be not builded, the majesty and estimation of the law shall perish, the justices being forced to minister the laws upon hills as if they were Bretons or wild Irishmen. I think we can be proud that those fears of the Tudor administrators in Ireland have now come to pass. Yet when I look out in front of me, I do not see wild Irish men or wild Irish women, but I do see a group of people who know that the courts in Ireland are devoted exclusively to serving those who seek justice. Gurmila Mahagiv Galer.
I would like to thank the Minister for those remarks, and I would now like to call on the Chief Justice to address us.
Good morning. I would like to start by welcoming some people to the four courts. In the case of the Minister and the Attorney General, it's of course a case of welcoming them back. And I hope our many distinguished guests here today will forgive me if I also welcome particularly some foreign judicial guests who have come to today's event. And we're very honoured to be joined by Judge Eugene Regan of the European Court of Justice and Judge Colin McGuckie and Suzanne Kingston of the CJEU General Court, by Judge Unani Rafferty of the European Court of Human Rights, by our friend, the Right Honourable Lord Stevens of the United Kingdom Supreme Court, by Dame Victoria Sharp, President of the King's Bench Division of England and Wales, by the Right Honourable Lord Doherty of the Inner House of the Court of Session in Scotland, and by our, I hope I can say, our particular friends from Northern Ireland, Sir Seamus Tracy, Lord Justice of Appeal, by the recently appointed Mr. Justice Paul McLaughlin, following in his footsteps of his distinguished father. And I just wanted to say to Paul that this is another occasion on which the O'Donnells got there first. And also Dame Brenda King, Attorney General of Northern Ireland. This is now the third year of the opening of the legal year in the four courts itself. And quite apart from the benefit of gathering together judges, lawyers, NGOs, senior civil servants and ministers and other distinguished guests, it also provides a platform to stand back and take stock of the court system and its place in our society. I think it is a very important convention that individual judges do not speak in public regarding matters of public controversy, that judges do not engage in background briefing, social media commentary, or any of the other methods of communication that are commonplace today. It's important, therefore, to take opportunities like these to say something about where the system stands. Inevitably, the issues I will discuss are somewhat random, but for those who have attended previous ceremonies, some things may be familiar. But in today's world, there is, I think, an increasing awareness of the importance of a court system in a modern, diverse and increasingly complex society. One marker of that is the significant increase in judicial numbers. 101 years ago, when the court system was established, as the Minister said, there were 9 judges in the High Court and Supreme Court, in the Superior Courts combined. Now there are 78. And that has put a significant strain on buildings, and this building in particular, as Ms. Justice Dunne has said. The momentum of modernisation which has been achieved within the court system in recent years has to be maintained if we aspire to provide a 21st century system of administration of justice which is the best that it can be And if that is to be achieved, it means having premises, facilities and support which matches that ambition. The increase in judicial numbers leads me to the next issue, which is to recognise the work of the Judicial Appointments Commission, which formally took up office on the 1st of January of this year, although it had been at work on an interim basis in the preceding months. Since then, the Commission has done a prodigious amount of work, establishing itself, finding premises, producing and published draft statements of selection procedure and requisite skills, knowledge and attributes. And the Commission also ran processes to provide nominees for vacancies in the District Court, Circuit Court, High Court and Court of Appeal respectively. And overall it considered 221 applications, which included 617 references, and in the end was able to provide 24 nominations to the government, which have already resulted, or will by the end of today have resulted, in the appointment of 10 judges. And that has all been achieved with a skeleton administrative staff of only 3 persons. And I would like to acknowledge the extraordinary work done by the staff of the Commission and by the Commissioners themselves, who I'm pleased to see here today, who have devoted an extraordinary amount of time and effort to that task. The Commission, both in its membership and its support staff, has made a very encouraging start and is working cohesively and effectively. But this system is not sustainable in the long run or even in the short term. And it is clear, I think, that additional staff are necessary to address the anticipated pipeline of appointments over the next period and coming year. It is important to acknowledge the fact that the Commission has made a very good start. The Act had a very long gestation and is the product of a number of different authors in different and sometimes conflicting perspectives and priorities, and has a number of features which could usefully be addressed to make the process easier and more efficient. But that should not obscure the fact that at its core, Section 39 of the Act is a structural, statutory commitment to appointment based on merit, which could not be more important in today's world. Confidence in the administration of justice begins with confidence in the appointment system, and confidence in the appointment process is central to encouraging meritorious candidates to continue to apply for appointment. This year also saw the publication of the report of the Civil Legal Aid Review Group. The review is something which I warmly welcome. It's really important that we should carry out a comprehensive analysis of the need for legal aid and assistance, the forums in which it has to be available, and the manner in which it should be delivered. The review was chaired by my predecessor, Frank Clark, and draws upon the work of the Chief Justice's Access to Justice Working Group, which was established in 2021 by Frank Clark and which I continued, and the findings of a high-quality conference in 2023 organised by that working group and focused on the question of civil legal aid. I'm old enough to remember the publication of the Pringle Report in 1977 and the scepticism then expressed about establishing a legal aid board. It seems that for all its lifetime, the Legal Aid Board has been severely stressed by the increasing demands made on it, and it deserves real credit for the service which it has nevertheless managed to provide. But it cannot be expected to continue in this way, and I hope that the consideration of the report will lead to a development of the legal aid system that will build upon the foundations of the Legal Aid Board and provide legal aid and assistance to those who cannot afford it when they find they must navigate an increasingly complex legal world. And anyone who comes into this round hall on a working day and who was around even 20 years ago would see a physical manifestation of a very significant change. A few decades ago, this was an arena in which very many personal injuries claims were brought, large and small, and adjudicated on or settled. But allowing all claims to come to this spot was inefficient and costly, and there have been substantial efforts made to reform that system. Now, much fewer, a very small fraction of claims come here for resolution. And the reduction in court resolution doesn't depend on just an impressionistic view of the numbers of cases on any given day. The Court Service's annual report for 2024 recorded that, to take one metric, personal injury awards in the High Court had reduced by 45% in comparison with the previous year, 2023. The reform of personal injuries litigation took some time because it requires a complex structure. In simple terms, there are 2 main components. What is now the Injuries Resolution Board, formerly the Personal Injuries Assessment Board, to provide the possibility of early settlement, and on the other hand, guidelines on awards intended to ensure consistency and predictability. Both of these have been established with legal structures designed to ensure compliance with the mechanism. The fact that the system is quite complex and sophisticated recognises the fact that the determination of whether a person has been injured through the fault of another, and if so, what compensation should be assessed, is and has always been a core part of the administration of justice. And any reform of the system is constructed around that fact. Therefore, and for example, at certain points, flexibility was built into that system so that, for example, the Judicial Council Act of 2019, which establishes the Personal Injuries Guidelines regime, provides that a judge and a court may depart from those guidelines, but must provide reasons for doing so. Personal injury guidelines were introduced in 2021 in accordance with the provisions of the Judicial Council Act 2019. Under that Act, the Personal Injuries Guidelines Committee had to take into account a number of things, including the levels of damages awarded in other jurisdictions as might be considered relevant. The committee took legal advice on this and identified England and Wales and Northern Ireland as the most useful comparators. It also took advice from economists on conditions in the economy. The outcome was a set of guidelines which established a relativity and proportionality between all personal injuries awards, scaled by reference to the award for the most serious injuries, and which resulted in a significant reduction in the awards for soft tissue injuries, which were the most common claims. And as most of us know, the Act also provided for regular review and required review of the guidelines every 3 years. That review is again a key feature of the system, and it necessarily contemplates that the guidelines will be updated in accordance with changes during that time to keep them up to date. The Personal Injuries Guidelines Committee, which was chaired indeed by Ms Justice Dunne, engaged in the exercise of revising the guidelines. It again took legal advice and the advice of economists. It was advised that England and Wales and Northern Ireland remained the relevant comparator jurisdictions, and it took account of the fact that both of those jurisdictions had procedures for the review of their guidelines, which provided that the awards were to be adjusted in line with changes in the retail price index in those jurisdictions. And accordingly, it recommended the same step here, and in due course, guidelines updated in this way were approved by the Judicial Council. As I think is known, as a consequence of the decision of the Supreme Court in Delaney and the Personal Injuries Assessment Board, the Act was amended to have any guidelines laid before and approved by the Oireachtas before they can have statutory effect. And as perhaps everybody here knows, there was a short media campaign that involved what I would regard as some misplaced criticism of the judiciary. As a result, it appears that the revised guidelines are not to be put before the Houses for approval. In this case, the Personal Injuries Guidelines Committee, the Board and the Judicial Council were simply complying with both the letter and spirit of the statutory scheme. But even someone who is concerned about awards and who disagrees with the level or disagrees with the level of recommended awards, whether generally or by reference to specific categories of injury, should not be opposed to the amendment of the guidelines. Looking at this purely from a practical and pragmatic point of view, it is simply counterproductive to seek to prevent the revision of guidelines in this system. The failure to update the guidelines will put the guideline system itself at risk. If the Injury Resolution Board and courts are increasingly invited to depart from the guidelines and make higher awards reflecting the effect of inflation, the guidelines will inevitably begin to fray. Over time, they will petrify and decay. And given the benefits of the guidelines in terms of certainty and predictability, it's not easy to understand why that would be allowed to occur. And this is an issue which we all have to face up to. Now, Alexander Hamilton, in the Federalist Papers number 78, famously stated that courts were the least dangerous branch because the judiciary had no influence over the sword or the purse, but merely judgment. And recently it has been suggested there has even been too much of that, and that in particular judgments of the Irish courts are just too long. Much of this commentary is of the casual variety that circulates on social media, and it is therefore perhaps not much different from public house conversation, which in the past would have been forgotten in the morning. However, nowadays, commentaries such as this have a half-life, which can leak into the water table and affect more general perceptions of and confidence in the court system. I think as judges, we are all painfully aware of the phenomenon of judgments of increasing length, and I can tell you that whatever effort it takes to read a judgment, it takes a lot more to produce it. We do look at ways of shortening judgments, by avoiding unnecessary disagreements and the proliferation of individual judgments in collegiate courts, and will continue to do so. And everyone aspires to the ideal of the succinct, elegant judgment encapsulating the principle and clarifying the law. But as anyone who has ever tried to write a judgment will tell you, it's not that easy. There are some points which I think have not been considered or considered sufficiently. Firstly, I think it's important to say this is not a phenomenon which is unique to Ireland. If you take our major common law comparators, England, Wales, Scotland, Australia, New Zealand, Canada, Northern Ireland, it's entirely commonplace to find judgments that exceed 100 pages. When the United States Supreme Court, whose reasoning is often compressed and criticised for that, recently overruled Roe and Wade in Dodds and Jackson, the judgments ran to collectively over 200 pages. Nor is this a phenomenon of common law courts alone. The European Court of Human Rights judgment last year in Clima Signorinen in Switzerland runs to 260 pages, which is still not even the longest recent judgment delivered by that court. Nor do I think the issue is limited to judgment writing. It's commonplace that trials, which in the 1970s took a few days, will now take many weeks. Textbooks are another useful comparator. Two of the landmark works in Irish law published in 1980 now run to over 2,000 and 3,000 pages respectively. The Companies Act of 1963 was a mammoth of its time, contained 399 sections and 331 pages. But the 2014 Act now runs to 1,648 sections and 1,415 pages. And the Local Government Planning and Development Act 1963 was a major piece of legislation of its time and ran to 99 pages. The 2024 Act has 906. So I think a question arises whether this can be treated simply as a problem or whether it is more accurately a phenomenon and a reflection of a number of things that have happened and are happening in the legal system. First, our system of law, and we're by no means unique in this regard, has become increasingly complex. Second, our expectation of how rigorous and transparent the reasoning of courts should be has increased considerably. And Lord Burroughs of the United Kingdom Supreme Court is someone whose opinion is entitled to particular respect, as he was a highly regarded academic lawyer before his appointment to the Supreme Court, and he was therefore both a consumer of and author, and subsequently author of, judgments. And he said this: no one ought to favour returning to the very short judgments on the law that predominated in this jurisdiction at the end of the 19th century. The reason that judgments on the law have become longer is because we have greater transparency of reasoning and greater rigour. There are many different audiences to whom a judgment is addressed, and some only want to know the what, but there are others who are entitled to the why. It's a fundamental obligation of judges, which I think we recognise today, to engage fully, fairly and conscientiously with arguments addressed by the parties. And in a world of increasing complexity, that means nuanced judgments and fine balances are an essential part of the system, particularly when dealing with cases which are recognised as being of general public importance. In that regard, I think it's worth saying something that doesn't figure in the commentary, and while I appreciate I'm not an entirely dispassionate observer, I think it can be said that the judgments of the Irish courts in recent times particularly are of high quality, and this really matters. Rigour, transparency and the fair analysis of the arguments of the parties are all essential to courts which have only judgment, and those judgments must command respect and acceptance by their own force. Now, I do understand the inward groan when confronted with a lengthy judgment, and that there are people who are interested only in the what that has been decided, or want to know whether they need to read in further detail. Since 2021, the Supreme Court takes the step of issuing at the same time of its judgments a summary of that judgment, explaining of what is an issue, what was decided, and providing cross-references to the relevant paragraphs of the individual judgments. And next term, the Court Service will start linking Supreme Court judgments and summaries on its LinkedIn platform, which has almost 23,000 followers, to make them available to a wider audience. And separately from this term, and starting on Thursday, the proceedings of the Supreme Court will be recorded and broadcast on the Supreme Court website. This is a pilot project because we have had to produce the system on something of a shoestring. The budget of the Court Service could not possibly absorb even a fraction of the cost that is involved in the transmission of proceedings in other jurisdictions. There are also technical constraints in broadcasting in a building of this age. The fact is we cannot stream the proceedings live, as it would disrupt the wider network performance within the Four Courts complex. So the proceedings in the Supreme Court will be uploaded to the Supreme Court website during the evening and made available the following day. Now, the debate about length of judgments and the length of proceedings, the need for concurrences or dissents, will always ebb and flow, particularly in common law courts and among those who take that business seriously. And it is a good thing that people take that seriously. I suppose, taking a more philosophical view, it can be said that if this is the worst thing on the judicial report card here, things are not too bad. And now, as anyone who has read my judgments will know, I could go on and on, but I think it's enough to recognise that this is at least a little more complicated than casual commentary might suggest. Finally, I do want to say something about the broader position of the courts in this country and their place in our system of government. We are living in dangerous times where there is now an increased understanding and appreciation of the role of courts in a modern liberal democracy. The fact, however, that there has recently been more focus on and appreciation of the vital structural role of courts in a modern democracy is itself a warning indicator that that model is under stress. But in these difficult times that we come to recognise that a court system, at every level of that system, is fundamental to a citizen's sense that they live in an ordered state with values of fairness and justice which therefore deserve their allegiance. But I think there's also an increased appreciation that the business of keeping the state on an even keel and maintaining the values of a Western liberal democracy is not a job for courts alone. There is a fine but strong web of office holders, functions, conventions, all of which together provide structure and resilience to a modern state. And many of those people and those institutions, many of those people are in this room and those institutions are represented in this room, including the legal profession, senior civil servants, particularly in the Department of Justice, the Court Service, the Judicial Appointments Commission, the Gardaí, the Army, the Public Prosecution Service, the Legal Aid Board, and NGOs who work in the justice sector, and the media who report it. On that point about the web of functions, institutions and conventions was made in a recent book, Could It Happen Here?, by Professor Peter Hennessy and Andrew Blick in the context of the UK constitutional structure. But that point also applies here. And it is really important that we take the time to check that web of institutions, conventions and structures, repair some strands and reinforce others. That, for example, is the importance of the Greco recommendation number 8 in its fourth evaluation of 2014, where it recommended that, quote, an appropriate structure be established within the framework of which questions concerning constitutional safeguards of the judiciary in connection with employment conditions are to be examined in close dialogue with judicial representatives with a view to maintaining the high levels of judicial integrity and professional quality in the future. Greco's recommendation, which was accepted by the government but has not yet been implemented, is important. Structures are put in place in the good times to protect against the bad times. Last year, Norway amended its constitution to enhance protection of judicial independence, not because of any immediate domestic concern, but because it saw this as a point of vulnerability that had been exploited in other countries. And in Finland, which is one of the highest rankings in Europe for perceptions of judicial independence, they have established a working group to consider reinforcing the safeguards for judicial independence, and we should not be complacent here. One of those conventions or structures which is often overlooked is overlooked precisely because it involves the virtue of silence. Courts have, as Hamilton said, merely judgment. And as I say, it's accepted that courts and judges do not engage with any controversial matters, and I think that self-denying ordinance is regarded as an important part of maintaining the distinct judicial role and respect for it. But it makes courts increasingly outliers in the modern world, and it means the system requires to be defended by others. And I would like on this occasion to acknowledge that on every occasion on which he speaks, Minister O'Callaghan has, to my knowledge, always taken the opportunity of expressing his belief in and support for the role of the courts, and I can say that that is genuinely appreciated by the members of the judiciary. But when we in the courts come to express appreciation for what the Minister for Justice says, it is not a personal thing or dependent on the identity of the Minister. There is a positive and constructive institutional and constitutional relationship that deserves to be recognised. Some friction between the executive and legislative branches on the one hand and the judicial branch on the other is an inevitable consequence of a system of checks and balances. Such moments of friction can be challenging for and skew perceptions of each institution involved, and it's important, therefore, to pause and take a broader perspective. One such perspective is that beneficial silence operates in both directions. It's important to recognise that there has been unquestioned recognition by the executive branch of the role of courts in our constitutional structure. That recognition is not merely perfunctory or performative, but reflects at its best a belief in and understanding of the importance of the system, which transcends any frustration or irritation or disagreement which may arise. In the 103 years of Irish constitutional democracy, there has been a strong and unbroken convention where the other branches of government have not merely accepted the decisions of the courts, but have accepted and supported the function of the courts and defended them when challenged. And looking around the world, in which the systems of checks and balances is increasingly being challenged in countries where it would have previously been thought unimaginable, that should make us realise that the relative stability of our system cannot be taken for granted. It is something that we must protect, renew and reinforce, and so it is particularly important to acknowledge it here, in this place and at this time. Thank you very much.
I'd like to thank everybody for being here today, but particularly I'd like to thank the Chief Justice and of course the Minister for taking the time to speak to us all today. I hope everybody found it very interesting. It's also important to thank all of you for being here today, because it is an important recognition of the importance of the new legal year, and I hope that this particular celebration of that function will continue into the future. I think the precedent has been set now, and it's an important feature of our new legal year. At this stage, all that remains is to, as I say, thank you all for being here, and to remind everybody that there are refreshments available in the King's Inns. Exercise and refreshment, what more could you want? Thank you very much.